But it's not just about winning. It's about how you win. I didn't have a suit, I must tell you. I had a blazer, and I would have a pair of khaki pants and olive green for in between. I think civility, grace, but most of all integrity should drive our practice of law.
Welcome to Celebrating Justice, presented by the Trial Lawyers Journal and Cloudlex, the next-gen legal cloud platform built exclusively for personal injury law. Get inspired by the nation's top trial lawyers and share in the stories that shape our pursuit of justice. Follow the podcast and join our community at triallawyersjournal.com. Now here's your host, editor of TLJ and VP of Marketing at Cloudlex, Chad Sands.
Welcome back, friends, to Celebrating Justice. In this episode, we hear from Mr. Gabriel Christian Esquire, a worldly trial lawyer with the voice and stories to prove it. Hear stories about his journey from the British cadets in Dominica to Georgetown Law School to tales about the Tuskegee Airmen and more. To start, I asked him, why did you want to become a trial lawyer?
I never wanted to become a trial lawyer. My dad, Wendell Mackenzie Christian, served in the British Army from 1943 through the end of the war, and then 2 years after that. He was born in a small British colony in the Caribbean called Dominica, not to be confused with the Dominican Republic. So Dominica is in the Eastern Caribbean. That's where Pirates of the Caribbean was filmed. I was born there in 1961. And when I started high school in the British system, there was something called the cadets. The Army Cadet Corps is like JROTC here in the U.S. So I joined the Cadet Corps at age 11 because my older brother had been a cadet at the St. Mary's Academy. I became a cadet at the Dominican Grammar School. And my other brother, older than me, Dr. Samuel Christian, when he got out of med school in D.C. at Howard, he also became a U.S. Army major, a combat surgeon. So he had a lot of military science and military sort of discipline in our household. And I only got the idea for law in high school because I became like a president of the Federation of Students, and people started saying, you know, Gabe, you speak very well. You should consider becoming a lawyer. So that's how that happened. I went to school in D.C. at the University of D.C. Business School. Again, you know, I was very fortunate. I had two mentors of note, and I want to remember them this evening. Dr. Albert Carter, who just passed, was my business law professor. We were at 10th and H, overlooking Ford's Theater where Lincoln was assassinated, and across from FBI headquarters. So I could actually see FBI agents across the way from my classroom in their offices. And he was a great professor. He went to Georgetown and helped me get into Georgetown. And my other mentor was Admiral William Ryan. He was a rear admiral. He was the deputy director of the Defense Logistics Agency, a graduate of Annapolis, the Naval Academy. When I did the LSAT and I went to him and I was thinking of a JD MBA, he said, Gabe, you've got a bachelor's in business already. Why do the JD? I think the MBA is a lot of sizzle and no steak. That was his comment, Gabe. It's a lot of sizzle and no steak. Why don't you just go to law school? And I entered Georgetown University Law Center on Capitol Hill. It's the only school in the country on Capitol Hill. Only law school right there next to Union Station on August 27th, 1987.
Tell me about your experience at Georgetown and how you got first into the courtroom as an early trial lawyer.
I mean, Georgetown is an outstanding school. Real estate people tell you location, location, location. So, I mean, I saw at Georgetown Jesse Helms, Senator Jesse Helms, Senator Edward Kennedy. Biden came through because in the foyer, in the lobby, they would sometimes have different organizations doing receptions. And the classrooms are arrayed around that main area. And they would have brie, cheese, and crackers and what have you. And you come to class. Since you're a Georgetown student, you can go ahead and have something too. No one's going to, shoo you away. And Stokely Carmichael came through. So it was an outstanding law school. My classmate on student bar was Mike Steele. Mike Steele is well known. He became RNC chairman and is on television quite often. He became Republican national chairman, and a lot of other folks who became ambassadors and what have you. So the professors were good. The trial advocacy class was taught by a current federal prosecutor who was moonlighting. So we had good talent at the school. But what really made it for me was that in the first year, against the rules, Georgetown at that time, I'm not sure what the rule is now, and my class was the first class where you were required to have a personal computer. Did not want first years to work because it's so tough in the first year. They felt that you had a greater chance of success if you did not work. They wanted to be focused. I was living with my sister who was finishing college. I was the primary breadwinner. I graduated already and I was working as a federal government contractor on a HUD contract, Housing and Urban Development contract. So I was the one bringing in the money. And if I stopped working, not only would I not be able to pay the note as far as the rent on the apartment, my sister was depending on me. So I had to get a job when my federal government contract ended in March of 88. And I saw a note in the Student Affairs office that says, insurance defense firm is seeking a law clerk for its litigation department. I did not know what litigation meant. It sounded like law to me. I didn't have a suit, I must tell you. I had a blazer, and I would have a pair of khaki pants and olive green for in between, and for formal, a gray slacks. But I was a working class student. I didn't have much fancy treads and all, and I went to Jose Banks. I bought my first suit. I went in with a t-shirt, my jeans, my boat shoes. Boat shoes, why? In college, in a business school, I worked on the D.C. waterfront. I worked on the old presidential yacht Sequoia. You see Jackie Kennedy and Jack Kennedy on. I worked on Trump's boat when you would visit D.C. I worked on the oceanographer Jacques Cousteau's Calypso. So I had 80 boats in the waterfront in D.C., and my attire was boat shoes, jeans, and T-shirt. So I went to Jose Banks with my boat shoes, jeans, and T-shirt. I only had $5 for the cuffs. That's all I could afford. In those days, I was as thin as a rake. I dressed, I did the interview. Chad, I'm still in the job. It was a 21-person white firm. I was the law clerk for the junior partner, John Smallwood. It was Farrington and Smallwood. Thomas E. Farrington was the basketball captain at Bethesda Chevy Chase High School, very well known, Washington Post sports page all the time. He was a basketball captain at William and Mary. There's a famous, he's since passed, unfortunately, there was a famous story. It said when Tom Farrington turned Jerry West. Now, being born in the Caribbean on the British Island, we played cricket and football. When I say football, we call it soccer in the United States. So I didn't know who Jerry West was. So at his wake, and I kind of got to go a little fast forward. I asked a lawyer, who was Jerry West? He says, Gabe, are you living under a rock somewhere? He's a guy on the NBA logo. That's who Jerry West is. So Farrington was a Yale University graduate, chairman of the Democratic Party, very dynamic lawyer. He represented all the big names, Lloyds of London, Fireman's Fund, Clement Forster, USAA, Allstate. So I was a law clerk at an insurance defense firm doing insurance defense work. And that's how I cut my teeth, doing pleadings and motions for summary judgment, discovery, supporting the senior partner. But I was a community leader at college in the Caribbean community, of which I was part, and I was bringing in business. When you're in a small firm or a big firm, whatever firm it is, business is a stock in trade. You have to be able to be income and not overhead. So by bringing in business, when I was getting ready to graduate, they made me an offer to become an associate. So I moved from being a law clerk, supporting the junior partner, John Smallwood, but I befriended the senior partner because he was an Army commando. He was a paratrooper. He had a club called the World War II Club, and this is why lawyers need to understand the importance of personal relationships in career development. So he was going to a dinner for the World War II Club. Who's in the World War II Club? Judges at the Court of Special Appeals of Maryland, circuit court judges, district court judges who were Marines or who were Air Force officers who had been in the Navy. He had been in the Army, and he mentioned something, and I said something about World War II. He says, Gabe, what do you know about World War II? And when I told him a few things, he said, Gabe, I'm going to invite you to the club. And he invited me to the club with all these judges. And what I'm going to tell you is going to be very emblematic of why it's so important to be studious, because law is about being studious, being able to have a control of the history of the case, being able to be learned in the use of language and in being able to research and effectively write that which you intend to have persuade the court to your point of view. Judge Jim Salmon just passed away. He was on the Court of Special Appeals. He was a member of the club. After the first dinner, they made me a member of the club. All the members are old enough to be my parent. They're all practicing lawyers or judges. I'm the only law clerk and the only black guy in the bunch. But I was, of course, very learned, and they enjoyed my company, and I enjoyed theirs. When I became a lawyer, I walked into Jim Salmon's courtroom one day. When I walked in, he says, ladies and gentlemen, hear ye, hear ye. Here comes Gabe Christian, who knows more about World War II than Ike Eisenhower. And everybody laughed. I think that sort of facility with history helped me in the law in a practical sense, because my first case represented the Maryland Automobile Insurance Fund. 3 other lawyers, plaintiff's lawyer and 2 defendants. It was a chain reaction collision on the Baltimore-Washington Parkway. The plaintiff's lawyer was doing closing, and he had a folio of loose leaf, 8.5 by 11 pages. And it fell to the floor, and it scattered. And he bent down, he says, beg your indulgence, Your Honor. And he's trying to gather his wits about him and get the pages back together again, and he couldn't. And he said, Your Honor, I rest. And it taught me that in trial work, to be persuasive, you need to be able to make a connection with the jurors, not stand there and read something like you scripted and speak with passion and with eloquence, hopefully, and with precision and outline the facts of the case that favors your side of the. I was able to show in that particular case that the plaintiff in the damages side, so my guy rear-ended, he was the one who caused it, but the damages were minimal. I was able in deposition of the orthopedic surgeon, after he had rendered his opinion within a reasonable degree of medical certainty and or probability, that it was my client that had caused the injury because of the rear end collision. And of course, my client had no defense. He didn't keep the appropriate distance. When he was finished and I'd locked him into his, you got to lock people into their positions. I said, "Doctor, is that your opinion?" "Yes." "And you're sticking with it?" "Yes." I said, "Doctor, this was a 1989 case, is that right?" "That's right." "Doctor, are you aware that your client was involved in an accident in Baltimore City in 1987? "That's right." "Did you ever review those records within the period prior to this trial?" "No." "Doctor, are you aware that your client had another accident in 1986, which he claimed injured him in the same area and for which he settled?" "No." "So, doctor, you did not get any records from the 1987 accident?" "No, I did not." "You did not get any records from the 1985 accident where he treated until 86? "No, I did not." And both of those injuries were for the lumbosacral cervical spine. He says, "Mr. Christian, I don't know." I said, "That's correct, isn't it, doctor?" Now, had you gotten those records, doctor, would that have made a material difference to you, the opinion that you've rendered here this afternoon? "Oh, certainly it would." "Thank you very much, Your Honor." And so what I learned in trial work is that having mastery of the facts, being studious, diligent, understanding the medical history, very important in success, but also being able to make direct contact with the jurors or with the judge.
I think your story about World War II and that little group got into really touches on relationships and how important that is for you guys, not only with other lawyers, but with obviously judges and everyone else, and how you need to kind of set yourself apart a little bit. So what makes you unique when it comes to other trial lawyers?
We are a community development law firm. We understand the importance of serving our community, not simply in law, but I'm the former or immediate past president of the Tuskegee Airmen. The Tuskegee Airmen, as you may know, were the African-American fighter pilots in the U.S. Army Air Corps in World War II. And because I was an old cadet, my dad had been in the war, and I've written the history of the West Indians who served in the Royal Air Force. Many people don't know that no nation or group of nations contributed more men to the Royal Air Force in the defense of Britain than from the British West Indies. Jamaica, Bahamas, Bermuda, Trinidad, 7,000. 7,000, several from my school, my high school, where I was a cadet. Before me, of course, they'd been there in the 30s and so on. So we serve to get young people to be disciplined and to enter careers in aviation science and aerospace. So we train young people to become pilots as young as age 15. That's a nonprofit. It's an Air Force linked nonprofit, but it's a nonprofit. And also to perpetuate the history, the noble history of the Tuskegee Airmen, because so few people understand that the Tuskegee Airmen not only did amazing things in the air, they were the best unit, but they also won the first Air Force Top Gun competition in 1947. The first Top Gun competition was won not by Tom Cruise, but by the Tuskegee Airmen. And the next year, President Harry Truman, on July 26, 1948, desegregated the U.S. Armed Forces. And so the Tuskegee Airmen was dismantled. The unit still exists, but it became integrated, and it scattered the pilots to different units. They never got to defend their tunnel. There's a lot of discussion about that. They came in with their own armorers, their own mechanics, their own pilots, and they came in as one unit because of the nature of the military at that time. They could not be transferred to other units. So if you're a white pilot, you could have gone to unit A, B, C, or D. But if you were a black pilot, you had to stay all through the war and for the period after in that one unit.
Can you tell me a story about the Tuskegee that maybe most people haven't heard of or don't know?
The second cabinet member in U.S. government history is William T. Coleman. He was in Harvard Law Review. He may have been the editor, I believe. He was a Tuskegee Airman. He was the Secretary of Transportation who brought in the airbag and the 50-mile-per-hour limit. But he did something that was even more marvelous than that, more amazing. He wrote the brief for Brown versus Board of Education. Thurgood Marshall argued the brief and may have contributed to it, but the primary researcher and writer of that brief was William Coleman of Brown versus Board, which everybody knows who knows about law, was the case that desegregated the U.S. education system, moving away from Plessy versus Ferguson of separate but equal to that not being acceptable, and that education should be available to all people in the United States without regard to race and not be subject to racial discrimination. So the Tuskegee Airmen not only did great things in aviation science, but they contributed many civil leaders who later on went on to great distinction in public life. And Coleman, I believe, stands at the apex of that tradition. But more importantly, I think it's linked to U.S. legal history. This is what happened. Yancey Williams in 1941 was a Howard University mechanical engineering student who applied to the U.S. Army Air Corps for a commission because he was a pilot. He already had his pilot's license, and they denied him because of his race. They said, we're not accepting blacks. So the NAACP, with the prodding rather of Yancey Williams, filed a lawsuit against the U.S. government for racial discrimination. President Roosevelt at the time, Franklin Delano Roosevelt, says, okay, drop the suit. We'll create in the U.S. Army Air Corps a black Air Force at Tuskegee, Alabama. So the Tuskegee Airmen has its genesis in law. It has its genesis in the NAACP Legal Defense Fund, which was started by Charles Hamilton Houston, who was the dean of the law school at Howard University, and his top student, a gentleman by the name of Thurgood Marshall, who became the first black justice on the U.S. Supreme Court. So that case, the Yancey Williams case, is what triggered the formation in March of 1941 of the Tuskegee Airmen. So here I am as a former president of an organization that would not have been born, had it not been for the intervention of lawyers from the NAACP. So I'm really proud of what trial lawyers have done, because trial lawyers really made our country, both in civil litigation, in tort law, for instance. We have a lot of safety rules in place because of lawyers like Ralph Nader, the consumer advocate, and others who litigate against pharmaceutical companies when they sell us bad products, litigate against bad doctors who leave sponges behind. You go in 10 sponges, you got to come out with 10 sponges. Don't fake the record and leave one behind. And I've had those kinds of cases. As a plaintiff's lawyer, of course, when I was a defense lawyer, we settled those cases. You know what I mean? Because the sponge is not supposed to be left behind. It's almost a res ipsa loquitur kind of case. And we just negotiate over the value of the case.
I know it's hard to pick one, but can you share a story about one case that really had a big impact on you?
I had a case recently that really gave me pause, because after 33 years, I've had the high honor and privilege of sitting on the Judicial Commission for the Court of Appeals of Maryland. That is, sitting as a governor's nominee on that commission to interview judges for the highest court in our state. That means sitting and interviewing judges who I have to appear before. So that's a high honor. And you don't put yourself there. You're recommended by your circuit. So I was recommended by the Seventh Circuit folks because they'd seen me blossom from a law clerk to associate to a partner before my partner passed away. So that was a high honor. And so I appreciate the rule of law. I wouldn't want to live in a system where there was no habeas corpus. I wouldn't want to live in a system where someone could just be jailed without the opportunity to get bail, to have a lawyer advocate for his release, and to not have the ability to appeal to a jury panel of my client's peers. Or if I elected, as I'm doing in the case on Monday, select for only a judge-only trial, which a criminal defendant has. This case involves a gentleman who had done a case for in the early 2000s, who owned a tow truck company. He was going to Panera Bread with his father one morning, and some guy accosts him outside Panera Bread, and then the guy alleges he pulled a gun on him. Now, my guy had a weapon on him. He is a business owner and had a concealed carry permit. So he was jumped by some police officers. He told him he had a gun, and they charged him with first-degree assault on this guy's say-so. Turns out that guy had a bad record for drug dealing, and they found about 20 baggies on him with what looked like street drugs, pills, maybe fentanyl, what have you. When we did the discovery, we got photographs that showed our client's gun in the same picture with the drugs. What's that about? The drugs were not found on our client. They're conflating the gun with the drugs. Then the case against the guy gets dismissed. They claim that the drugs were fake. They claim that those were placebos or something. I don't know that to be true. Then they want my guy to take 5 years, mandatory 5 years. This is within the past year this is happening. And I'm seeing all of these issues. I take 6 members of my staff to Panera Bread on a bright morning where the conditions, the climatological conditions, visibility, timing, everything is about the same as the day of the incident. Turns out, when we have body-worn camera, where the officers are speaking to the Panera staff, nobody recalls an altercation. The Panera Bread has plate glass windows, plate glass doors. If there's an altercation outside where they said it happened on the front of the building, guess what? All the people in there who were sitting down having a meal would have seen it. The staff had an impeded view of the exterior. And we had body worn camera where the police are asking patrons of Panera Bread, what did you see? And no one saw anything like what the government was describing this guy alleged happened.
Even in the body cam footage, you have the police talking to the people in the Panera, and they're all saying,
Talking to the people at the Panera, and they're saying, sir, we don't know what you're talking. We didn't see anything. Nobody made any complaint. The other people are sitting there. Nothing. Their cameras, their CCTV, the CCTV picked up nothing. Up to the day before trial, we all sat after having gone to the scene and taken pictures. Because another thing I want to say to young lawyers, do not, especially when you're talking about someone's life, pull any punches. You have to be deliberate and relentless and focused and pull out all stops to ensure that the justice system works. And unfortunately, in our society, too often, people, especially if you're poor, you don't have the resources, the public defender lawyers are very good lawyers, but they are burdened. So the office of the public defender oftentimes is not well resourced. The lawyers take the same bar exam I take. We have Katinji Jackson on the Supreme Court. They're fine lawyers. I know because I work alongside them in cases where they're co-defendants. I know their value, but they are oftentimes without the adequate resources. I don't know whether they would have taken a bunch of staff members to Panera Bread on one morning to sit around and take pictures. That's what I did. So we're all set for trial, and the state says, well, Mr. Christian, this, that, and the third, can you take a step? We'll retain the gun. I was so upset because I was all set for trial, and I was all set to unmask what I thought was a gross miscarriage of justice. But when you work for a client, you cannot interpose your feelings over that which is in the client's best interest. What is my objective as a client's attorney? What is my fiduciary responsibility? To get him out of trouble, prevent him from going to jail. No matter how good I am, and I know I'm good by God's grace, not because I'm better than anybody else, I think I've been blessed. I couldn't guarantee that for him if we went to trial. I almost most certain we would win, but could I guarantee that? No, I could not. So I said, you know what? Instead of a year's step, we'll do 6 months, and then you'll enter it nolle prosequi, which means dismiss it. He said, sure deal, no deal. And we walked out with our client. He took our entire staff to dinner, and we're very happy, but it says to me that we must understand that the justice system is only as just as the just people who work it. If we have people who are unjust who are police officers, if we have people who are unjust who are prosecutors, if we have people who are mean and who are unkind and who have no respect for our laws and constitution, we can have enormous injustices be inflicted on the poor and people who, because of their ethnicity, may not be favored. But we have to be able to work to ensure our justice system saves our Constitution, but serves those who are Black, who are white, who are Jew, who are Gentile, who are Hispanic, or Asian, without regard to any race, creed, class, or color. We have to make sure that we keep the doors of justice open to all who come within the inner sanctum of that temple of arbitration of civil matters, adjudication of criminal matters, and we have to make sure that we, as lawyers, are exemplary in doing the best we can, using our intelligence or diligence or discipline to ensure that justice is served.
And you're not just like personal injury or criminal defense.
No, so we came out of, so let me explain. So the insurance work, I talked about Tom Farrington, that was his work. We represented the hospital system and so on. But towards the end of his life, I was getting conflicted out. People would come to me with USA or Allstate. I couldn't take it because I was defense counsel. When he passed away in 97 and 98, I handed over my last insurance defense cases because I had enough plaintiff's work. So we do plaintiff's personal injury, including medical malpractice, auto tort primarily. We try those cases that we're not getting fair offers on because we're not afraid to go to court. You've got to let the other side know you're prepared to go all the way. If not, they're not going to, do right by you. And it's hard to be a good African-American lawyer, frankly, as Johnny Cochran found out, and not do criminal defense. So what happened is in the 90s, people started coming to me with DUIs, assaults in first degree, second degree, murder. And I did my first murder case in 1995. A 14-year-old who was kept 48 hours without food or drink.
He was accused of murder at 14?
She was.
She was?
She was accused of being, along with another young man and a gang leader, being part of an initiation for the Crips. It was a fight, and you're not supposed to hit back. And the young lady who has been initiated supposedly fought back, and she was stabbed 16 times. And my client may have stabbed once, but at the end of the day, it's a very emotionally driven case. Confession she made, she said that the police told her, just confess that you just gave her a little stab wound, but it wasn't so deep, and we'll take you to McDonald's and bring you home. She said, okay. So I stabbed her, but it didn't go in all the way. Can I go to McDonald's now? And of course, that was not going to happen. So those are the kind of things that happen in when you have juveniles, you have police officers who are skillful, you can have a lot of misconduct. Yeah, and I want to take this opportunity to say my dad and his father, so my dad and granddad were police officers in the old British system. So I have a healthy respect for police officers. I've represented the police chief in this county. I've represented a lot of officers, a lot of respect for state police officers, what they do. But there are officers who shouldn't be on the force. I've caught too many officers who have taken a license. And one of the things I learned in that murder case from a guy called William Brennan, he said, Gabe, when you get discovery, like probable cause statements, read every single word once, twice, and 3 times. Look at every date. Look at the numbers. Look and see if you see cut and paste. I mean, I can't tell you how many cases I've won since that guy, he represented one of the co-defendants in that case, the murder case I told you about from 95. And Brennan, if you're out there listening, thank you, sir. He was so right. I mean, we just had a gun case. I'll tell you because it's something that is really relevant. So my guy was stopped in a neighborhood. No, he was in a neighborhood, had a gun, and I can just admit that is true. And he was stopped. When I got a probable cause statement, the officer who wrote it was not the officer who stopped him. He wrote the statement, but he was stopped by 2 other officers. So I immediately realized that the author of the document that said there was probable cause was not the actual person who did the stop.
Was she even there at the stop?
Well, this is what happened. She said she saw the car go by in the parking lot.
Okay.
And she believed that it had tint that was below the accepted threshold for tint. But she didn't do the stop.
Right.
She called on radio, and some officers a mile away did the stop.
Oh, she radioed ahead?
That's right. So when I asked them what probable cause did they have to stop the guy, they could not tell me. And then I had to extricate and extract from them, sir, I put it to you that you stopped him because you got a call, didn't you? Yes, Mr. Christian. And I showed them the probable cause statement. I said, that's not in the statement, is it? No, it's not.
So what happened?
Well, when I brought her on the stand, remember, there's a rule on witnesses. So she's not in the courtroom when I'm interrogating the other officers.
Right.
I said, ma'am, you wrote the probable cause statement, did you? Yes, I did. You said there's probable cause to stop the guy, didn't you? Yes, I did. Well, you didn't stop him, did you? No, I did not. In fact, you allowed the car that you thought had an impermissible level of tint. You allowed it to go, didn't you? Yes, I did. So you can't tell us whether there's a gun in the car because you didn't see a gun in the car, did you? No, I did not.
So what happened?
So the case was dismissed. My guy, frankly, be honest with you, he got away, and I warned him. I said, never do it again. He had a gun in the open. He didn't have a permit.
Right.
You don't have a permit and you have a legal firearm. It must be unloaded and in the boot of your car. It must be out of reach. It must not be within easy reach for a variety of reasons, public policy reasons, road rage being one of them.
Yeah.
If you have a gun next to you, you get in a road rage situation, you can pull it, shoot somebody. But if you have to get out of your car, first of all, open your door, get out of your car, hopefully close your door, go to the back, open the boot,
Load the gun.
Yeah. All of that gives you time to do what?
Cool down.
Cool down, right? And so he had the gun where it wasn't supposed to have been, but because the police officers procedurally violated his rights to privacy, he was able to get away. So that again had to do with a very skillful and very deliberate, dissection of the probable cause statement. So I tell young lawyers, when you get, long form Miranda statements, look at the date. Is it signed? Are the boxes checked off? You got to make sure that you go through in a diligent manner to sort of excavate from the probable cause statement whether they violated the constitutional rights of the motorist or someone who they may have accosted and that type of thing. Up till the last moment, you got to keep putting the pressure on and doing your best for the client. So that at the end of the day, you can go home and rest quietly knowing that you did your best. You're not going to win everything. That's just impossible. Some cases are such that they have to be played out. Some cases are such that they, maybe lesser offense, but you want to make sure that you put forth your best effort. I always try to be measured because I think, there are points to be made on both sides. But the fact of the matter is we have to try to respect our courts because at the end of the day, this is what I learned. The executive branch has the power of the sword. The president can call out the National Guard. They can send the troops into action. So too the governor call out the state police. That's the executive. The legislative branch, well, they pass laws. They pass the budget. They can fund you. The Congress, they can fund you. They can defund you. They can underfund you. That's the legislative branch. That's the power of the purse. Well, of the three enumerated powers, I've talked about two, the executive and the legislative.
The sword and the purse.
The sword and the purse. Powerful, right? Powerful. And here comes the judicial branch. Man, Chad, shame, shame, shame. Compared to the sword, compared to the purse, on the face of it, you are the weakest of the enumerated powers. Because all we have is the power of the pen. That judge who wields that pen and signs on that order, you would say, when you look at the purse, when you look at the sword, if you've got a bag of gold coins, you can knock someone over the head with it. A sword, you know what you can do with the sword. A pen, what can you do with that? However, the pen, by the force of its logic, of its reason, of its justice, of its process, the due process it gives to us, flawed though our society is, we know perfection reigns only in heaven. In a great many ways, our system is still, in my view, superior to most systems on earth because it has allowed us to abolish slavery. Well, we had a civil war. There's a little bit of that too. Deal with racism, deal with human rights in a way that is the envy of the world. And so I say to folks, respect our courts, respect the practice of law, and to lawyers I say, be involved in your community. Let's burnish the image of law. Let's not be seen as simply folks who are interested in a fee. I get criticized at my office because I do a lot of pro bono. In fact, Judge Vincent Famia, I walked in one day, he had something called a rocket docket for DUIs. And he says, ladies and gentlemen, here comes Gabe Christian, the best lawyer for the lowest price or no fee at all, the pro bono king. And everybody laughed, and it's okay because it's all right to be able to take some time to save the image of our profession by serving others without regard to a fee. Because, the Shakespeare who said in one of those famous quotes, first, let us kill all the lawyers. So I don't agree with Shakespeare. I say, let's save the lawyers and let's save rule of law, because rule of law allows us to live in a society that is much more predictable. It allows us to avoid vicious whimsy. It allows us to go into the temple of justice and have our case be heard. And hopefully we get a good and fair result. We can't always win, but let it be that we are guided by learned effort and due process, so people feel respected and that they've been served well.
At CloudLex, we understand the challenges personal injury law firms face every day. That's why we've built the Legal Cloud platform to help you stay productive and keep your cases moving forward. CloudLex provides a comprehensive suite of applications and features to support every stage of intake, pre-litigation, trial, and more. From innovative case management to insightful analytics and HIPAA-secure client communication, CloudLex empowers your firm with the technology to thrive. Build your firm of the future and see for yourself at cloudlex.com. Now, here is this episode's closing argument.
I think civility, grace, but most of all, integrity should drive our practice of law. Let's start with civility. I am where I am because I had a good mentor. But before him, I had good parents who were kind and who were disciplined. As I said, my dad was a soldier, police officer, firefighter. He died at 90. My mom's 94, going to 95. She was a nurse, Red Cross volunteer. Her name was Alberta. My father was Wendell. She was the director of a school for the blind. And so we had to, as kids, go around the blind school and sometimes help lead them by the hand and take them home. And that was before the ADA, that was before the consciousness of disabilities and being respectful to the disabled. People were very disrespectful to the disabled when I grew up on the island. So I grew up in a home that had a high degree of social responsibility and service. When my wife jumps in front of me and says, hey, don't you go and volunteer again, you volunteered out. I remember, I'm the son of my parents, they served. So civility comes from that because you're more likely to be civil to your colleagues and before the court where you've been inculcated with that spirit. And I'm saying that to the young lawyers who believe that it's all about jumping up and shouting and being ungracious and ungrateful and not shaking hands. I mean, I shake hands with most of my colleagues, win, lose, or draw. Win, lose, or draw, I say, fine job, we'll be back again. Different day, different subject, right? Don't interrupt your colleague when they're making argument. Be gracious to the court, be respectful to the court. It's how we earn our living. We're not each other's enemies. We're here trying to do a job. So civility is very important. Grace is important. And I'll give you a good example of that. So when I was a law clerk, you want to please your employer, right? So there's a guy it's a PI case where you're doing work for USAA, and you got to answer interrogatories within 30 days. And I'm looking at the clock, and the 31st day he's not answered. I ran up, I did a motion for sanctions, right? You can ask for sanctions. And one of the sanctions, ultimate sanction, is precluding plaintiff or the party on the other side from testifying. So I went up, the judges knew the senior part of my office, they knew me, I was coming there often. And it was the time of the first Iraq War, and the judge and I talked about the Iraq War, and he says, what do you got here, Gabe? I said, motion for sanctions. This guy didn't answer. He said, oh, where do I sign, Gabe? And he signed. So when I got back to the office, I was very happy. I'd done a great thing, I thought. And the junior partner, John Smallwood, said, Gabe, do you know what you've done? You've just had this guy commit malpractice. Call him and give him 7 more days. One of these days, you're going to be a lawyer. And you're going to do something, you're going to fall short, you're going to forget something, and you're going to hope that the lawyer on the other side has grace. It's not about winning, always. And I called the guy, I was a little crestfallen, and I gave him 7 more days, and he answered. But I learned something in that moment, that you have to have what is called professional courtesy at times. Not all times, but, you have to have that. And finally, you have to be a person of integrity. I remember one time there's a pro se litigant in a family law case. We do a little family law. And he'd filed something, the jacket, it was not yet electronic. The court jacket didn't have his pleading, but I had it. And I could have just remained silent and not said anything. And I examined my conscience, and I said, Your Honor, may I approach? And I said, Your Honor, what this guy is saying is true. I have the paper. For some reason, the clerk maybe didn't file it properly. And I eventually prevailed because I just had the better facts on my side. And my client was upset. She said, why are you doing that, Mr. Christian? You're helping the other side. I said, no, ma'am. I'm not helping the other side. I'm helping the cause of justice. Because I always believe in the old golden rule. I know it sounds maybe kind of strange coming from a lawyer, but it's not just about winning. It's about how you win.
That was trial lawyer Gabriel Christian. Thanks for sharing those stories. To learn more about Gabe, visit his firm's website, marylandattorneyatlaw.com. All right, I'm Chad Sands. Thanks for listening. See you next time.
You've been listening to Celebrating Justice, presented by Cloudlex and the Trial Lawyers Journal. Remember, the stories don't end here. Visit triallawyersjournal.com to become part of our community and keep the conversation going. And for a deeper dive into the tools that empower personal injury law firms, visit cloudlex.com/TLJ to learn more.